Sanbonani, Dumelang, Abosheni, Inhlikani, Imadambulamanini. Good morning, good afternoon, and good evening. My name is Sophia Butomi Mburi Yakachabalala, and welcome back to Second Chances with Sophia V. Today, I will be doing a video on child maintenance. If you feel like you are being financially taken advantage of when it comes to the demands being put forth to you when it comes to the needs of the child, or you would like to hold the other parent financially accountable for their responsibilities, or whatever your situation is, but in relation to the needs of your child, then you've come to the right place. This video is definitely for you. On this video, the aim is to take away any misconception around child maintenance court. And if you're someone who's currently financially being stranded or financially being put under pressure when it comes to raising your child, and you are busy considering your options, this video is to help you consider the maintenance court route with an informed mind as to what you might possibly expect when you do decide to make an informed decision and go with this route. So this particular topic will be broken down into two parts, which is the part one, which is exactly this video. We will be covering what to expect and how to apply or go about applying for child maintenance and how you can best prepare yourself. So in part two, I will be breaking down that now you are done with the whole application process. This is the court date. Now what can you possibly expect? Although this video is not 100% foolproof, I do believe that it might offer you some sort of an idea as to what the journey, should you decide to go this route, might offer for you. So towards the end of this video, I will share with you my own personal experience as to why I took the father of my child to maintenance court, because yes, I have been through this process. So one thing that I do need you to take into consideration is that the court does not care about the relationship status of the parents at that particular point in time. Whatever your situation is, the court listens to you. You might, whether you're still together or you are not, you might even be still living under the same roof, but you feel like your partner is making you suffer by depriving you the financial support that you need to take care of the kids while you are living under the same roof. By all means, you can do that, and it is completely free to a certain extent. So you should definitely consider this option if you have the will and you feel like you are being abused or deprived in any way, and it is completely free to a certain extent. So if you would like to learn more about this, please do stay tuned. If you feel like this video is not for you, I would urge you to please share it, because looking at the statistics, trust you me, there is at least one person on your contact list that might find this information very helpful. The statistics show that in South Africa, there is a 67% going around whereby kids grow up without fathers in their household. And then there's also a 39% that says that kids grow up in the house without their mothers. So while these kids grow up with their parents in their lives, who is taking care of them financially? Let us do right by our children. Let us do right by children to make sure that they get the best out of the situation that they can. Even though their parents are not emotionally, their finances play a huge role in terms of raising a child. So yes, without further ado, please let's take a short left to a quick disclosure, and we'll get right on to the video. Quick disclaimer, I'm not an attorney, a lawyer, or any legal law enforcement of any sort. I speak purely from a point of experience, and this video should not be used to be or quoted in a place of law. So you're still here. Great. I will break down this video that is going to help you prepare for the court date before you can go to maintenance into three parts. Part one: who or what age does a child need to be supported or maintained up to? 2, who can be sued or is responsible to maintain the child financially, and 3, what exactly you can do or how to go about the application process. So let's dive right in. The law says that the child from the ages of 0 should and can be supported up until the age whereby they are legally able to support themselves. That is the terminology that is used by law. It does not say 18, it does not say 21. It says legally able to finance themselves. So what exactly does that mean? 1, it means that you need to stop counting because there is no age limitation for maintenance in South Africa. To break it down for you a little bit further, it says that to break it down for you into simple terms, basically it says that there is no age restriction. However, the court may consider your particular situation to say that maybe if your child is about 30 by now, it can say that it can deem or the court can say to your child that by now you are capable, or you are at an age and you do have the resources to be able to go and seek for employment and be able to sustain yourself. However, maybe a child by the age of 25 is still in university and still studying. Their court can require you to continue maintaining the child. So if you were counting down the years, just stop it. Secondly, who can be sued for maintenance? There are different people that can be sued for maintenance, but the one that is on top, and I believe it's very obvious, is that both the biological and adoptive parents of the child can be sued for maintenance. And I'm choosing the word both very carefully. When I say both parents, I am referring to the mother and the father. However, if a child is adopted, you cannot claim maintenance from both the biological and the adoptive parent. You can only claim from one, and if you would like to know more about it, you can do your own research, but that is as far as I will take it. You can only claim from one and not two at the same time. So going back to both, the terminology of both parents, you know, when they say that it takes a village to raise a child, it means exactly that. Because should the parent not be able to take care of the child for whatever reason, now we can go back and actually sue the grandparents of the child. So basically, even if the parent, the one parent is unemployed, it does not take away the responsibility for you to take care of the child, because their needs still stay. So when you go to maintenance court, basically irrespective of your financial situation, the law is going to consider both the mother and the father, bring together their income, and from there decide a certain percentage as to who should contribute what percentage towards the need of the child. But irrespective of your financial situation, you are required by law to take care of your child. I believe when the court was making when the law was being set up, the mentality around it was that even if you are unemployed or even if you are not financially well off, you are still able to go to bed with food in your stomach. You still have a roof over your head. So wherever you are getting those things, whoever is providing for your needs as a parent, then they should be able to make provision and provide for your child as well, because the child's needs do not suddenly come to freeze, and they do not suddenly stop being hungry until your next phase in life where you are financially independent. So I need to emphasize that irrespective of how you are in terms of your finances, whether you are poor and the other parent is very rich, you are both expected to contribute. However, the percentage will depend specifically on who earns the highest, and the one who earns the highest will be given a higher portion to contribute, and it depends on case to case. So no two situations are ever the same. So if you had someone tell you something somewhere out there, just consider your own special circumstances at the same time, and not take it as though that will apply to you 100%. So if you want to go through this route, just keep that at the back of your mind, that no two people will get to contribute the same amount, as I have mentioned, that it is based on that particular situation. So now going back to the adoptive parents, So when a woman is married to a man in community of property, basically the children that are being made out of wedlock, the children that are conceived, whether it was before they got married or they are conceived during that marriage, at the end of the day, the woman puts herself in the line or in a situation whereby the mothers of those children can come back and claim maintenance from the wife. Yes, as a wife, your salary or your income can be garnished so that you maintain your husband's outside children. However, it does not become an automatic thing that the husband, even though he's married in community of property, it does not become an automatic thing that if the wife now comes with children from outside that marriage, he will have to be garnished, or he will be liable to take care of the kids' needs. It is not an automatic thing for a man. The man needs to legally adopt those children. Yes, there is not an agreement between the two people, and even so, the husband in the house, there are no limitations. He can support the kids. However, in terms of should you want to go through the maintenance route for whatever reason, you cannot sue the husband for maintenance unless he has legally and officially adopted the kids in the right way. So that's something else that you also need to consider. And lastly, it is not impossible, and as far as I know, it is not a common situation, but it is not impossible either. There are extreme situations whereby even the siblings of the parent can be sued for maintenance. So those are like different categories of people that can be sued for maintenance. To the third but yet very important point: how do you go about applying for maintenance, and what things are considered when you apply for maintenance? So basically, maintenance court is applied for in the region whereby the child resides in. So you should consider going to the magistrate court in the region whereby the child resides in. Be it you are a parent, be it you are a guardian, you will definitely be welcomed. So what to expect when you go to the magistrate courts? When you go to the magistrate courts, initially there is no need for an appointment. You will go there on your first visit. You will be given a J101 form, which you can also download online on the link that I'm going to share on the description box below. So when you get that form, basically what you will be required to do is to fill in the particulars or the details of the mother, of the father, and give a financial breakdown in terms of the commitment that you as a parent, if you happen to be the parent who's filing it, you give in the financial commitments that you have as a parent towards yourself, and then you also give a breakdown of the needs of the child. So by now I should be showing the form on my screen. So you will be able to see that when I'm talking about the financial breakdown, basically there is a children's bill of rights which breaks down the rights of the child and their responsibilities. So basically that particular form that I'm referring to, it is giving you a detailed breakdown of what the court will be considering. For example, there are 5 rights and needs that are being listed there. The child has a right to accommodation. The child has a right to accommodation or shelter, for one. The child has a right to food. The child has a right to basic education. The child has a right to basic health care. The child has a right to entertainment. So those are the kind of things that the form will be expecting you to sort of fill in. And you do not just stack thumb the amount that you're going to put in there. Initially, when you go to the court and you fill in that form, it is just you filling in the form and the numbers. However, when you do go back to court the second time around, you will be expected to provide support or evidence of all the expenses that you have listed on the form. So the law is and the court is very much fair, and it is very much taking into consideration their expenses and the commitment of both parents without compromising the needs and the rights of the child. If you have noticed, they use the words such as basic health care, basic education. So yes, it is something that I will break further or go into detail in the second part of the video as to what exactly that means, so that you do not suddenly go and take your child out of the school that you can afford and put them in an expensive school all of a sudden, even though you cannot afford it, because the law requires for a child to have education. No, no, no. Do not overlook the terminology. It says basic. So those are the kind of things that you will break down when you, and in detail, and discuss when you eventually go back to court. So after you fill in that form and you hand it over at the magistrate court, whether you have downloaded that form yourself and filled it in at home, or whether you actually get the form when you go to the magistrate court, fill it there, you are eventually, the last step in the application process is that you submit it at the magistrate court. So when you submit the form, they will issue you with a with a case number and the date at which you need to come and appeal at the court. Also, going back to the point that both parents are expected, responsible, and liable for the financial needs of the child. The terminology says both parents. It does not say that the father is. So even if you, as the father, you are the primary carer of the child, you are still you can go to court as the father on behalf of the child and take the mother. There is no shame in that. At the end of the day, it is all about the child more than it is about you. Even as the guardian, you can take both the mother and the father to court so that you can get financial support from them. So there is no shame. The court is open to everyone and it is free of charge. Now, once the case number and the court date has been issued, it's either you leave the form there and the court will and the court or the magistrate will be responsible to deliver those summons, because they do need evidence that the other party did receive or the other parent did receive those summons. It's either you leave the forms there and the court will be responsible to deliver those summons to the other party. And let's just make it more practical. Let's say I'm the woman. I'm the one who took the father of my child to maintain his court. So it's either I leave the forms there and the court will be responsible to deliver those summons to the father of my child. Or the second option, which I found to be more effective, is to actually take the summons with you to the nearest police station to where the father of your child is located. So the police station are well aware and are equipped to handle such situations, because there is a special department that is allocated to deal with such situations. So when you take the summons to the nearest court or to the nearest police station, when you are there, it is either the police call the father of your child to come to the police station to sign for the summons, or they will personally go out to the address that is you have provided them with to go and deliver the summons. This will be very much helpful should your father of your child not come to court, because yes, best believe it that there are steps and actions that the court can take against the father of your child should they decide to disobey the court and the order. I forgot what the actual things that they are that they can do, but if there are any legal professions on that are currently watching, I would most appreciate it if you could watch, or if you could comment and advise us on the comment section below and let us know that what steps are being taken and what the consequences might be if the person does not come to court. So next, now you filled in the forms. You are in the waiting process. How do you prepare yourself, and what kind of documentation will you need to present when it comes to the court date? I would personally advise you that from as early as you possibly can, do start collecting receipts and evidence or support of any expenses towards the child. So when you go to court on the court date, the court will expect you to provide evidence in a form of receipt or documentation or agreements on whatever expense that you have listed down on the form. They do not want you to suck out amounts from your thumb and just make them up. That is why it is very important to have evidence. Something that I have learned and I found very quite interesting on my own personal journey: did you know that when it comes to the right of a child having shelter or accommodation, that the court will consider, if maybe you are paying a bond, or you are staying in a family home, or you are even you are leasing, whatever payment you make towards that home, whatever payment that you make, you present that support to the court when you eventually go to court. And the court, by virtue of the child being in that house, obviously there are certain things that deteriorate in a condition by the virtue of the child being there. So the court will determine, based on whatever formulas that they use or percentage, they will calculate a certain percentage of whatever money that you are making and consider it a contribution towards what the child makes. So you can put the full amount of the bond that you are paying, or whatever it is, and the court will determine what percentage is applicable to and can be used as a contribution, or the child's contribution towards the household. Water, electricity, those kind of bills, the things that the child makes use of, or by virtue of being there, they will be used towards them. The court will take those into account or consideration, but they will obviously not expect the child to pay the full contribution. However, they will determine what percentage would be suitable for them. Even policies, if you have any policies, investments, you can receipt if you buy the child clothes, food, you pay for entertainment, even the present you buy to the child's friends when they are having a party. All of those things are taken into consideration. So whatever expense that the child accumulates, whatever you can think of, anything that you buy, or any rent or any cent that you spend towards the child, just make sure that you put support for it, because that will be required and might come in handy when you go to court. The court is very much fair, because it will also consider if you have other biological or adoptive children that you are taking care of, or other dependents that you might have. So the J101 form that I have mentioned previously does list all this documentation that you will need, such as the ID copies of your dependents, ID copies of yourself, your pay slip, your 3 months bank statement, all of those things. The form will be able to guide you. But these are some of the things that I thought might be helpful for you to consider while you are going through this process, or even while you are still considering what it might take. So why did I take the father of my child to maintenance court, even though he was paying contribution towards the child? So when the father of my child and I separated, our son was 6 months old. From the time before he was born, we were saving money into a joint account, which we were using from the moment the child was born towards the child's need. So when we separated, the father of the child was still sending me money on a monthly basis, but we never sat down to discuss how much that amount is. So I took him to court for 2 specific reasons, which made sense to me and nobody else, just me. So 1, I wanted a formal documentation, so that should anything happen to one of us, I needed that document to be the one to speak on behalf of the child, so that financial needs would still be taken care of. God forbid, I'm not wishing anything bad to happen towards the father of my child, because he's an awesome dad. But I really, really, really needed something, because life is not guaranteed. We don't know where tomorrow will take us. But I needed that documentation to be able to be there and speak on behalf of my child. So I needed that formal documentation. Specifically, I keep on saying formal because I really, this meant so much to me to have something formally and legally documented down. Because now we had separated and we had agreed that we will no longer be in each other's lives. And for that reason, I believe that both of us were now going to move on and we're going to have other people in our lives. I did not know what role they will play when they come into my life, or how well taken care of my child will be. So I needed us to cement, to have a foundation of my child's needs even before we bring other people into our lives. I wanted a situation whereby if ever he meets someone in his life, and that woman, whenever she's considering the household income of the house in future, if maybe for instance he's earning 100 rand, I wanted her not to consider 100 rand as his contribution towards the household income, because the same way there were deductions at work such as medical aid and UIF and other things, I wanted that maintenance order to also form part of his deductions, and she would only consider 85 rand, for example, if maybe I was granted 15 rand, to be the household income. I did not want an oopsie situation. This month my things did not balance, or I now have new responsibilities, things have changed, new priorities have changed. Nope. I needed him to know and also plan around whatever net amount he would have left after his priorities, which would, number one, be our child, would have been. So for me, a formal document was of utmost importance, and I would urge you that if you are in a position whereby there are no disputes between you and the other parent, and you are able to agree and talk and sit down and talk, rather get a private mediator if you have the financial means to do so, and have whatever agreement or whatever points of discussion that you agree on be documented somewhere. If you do not have the funds for a private mediator, which was also in my particular situation, that was the case, consider going to the maintenance court to use the free services of a mediator. The second reason why I took the father of my child to maintenance court was for my own financial planning and budgeting. So I'm an individual who likes budgeting, and as you can imagine, after going through a divorce or a separation from a lifelong partner, your finances do get affected. And also in my case, because I was with the father of my child for close to 10 years, my finances were mainly joined with him. So us separating meant that my finances were also shaken a bit, and I needed to make changes. So I needed to know and have it cemented somewhere that I will get X amount on this X date. I did not want to just be grateful when I get a bank notification and say, oh, he cares about his child. No. I needed to know in advance that I will be getting this money so that I can add it onto my budget. For example, as I hire a helper, I needed to make sure that if I'm going to hire whether it's a day nanny or whether it's someone who's going to sleep over, those expenses differ. But if I know that this is how much I will be getting on a monthly basis, I'm able to plan around those things. I'm able to plan when I'm going to buy grocery, when I'm going to pay this and that. So it was very, very important for me to have some sort of structure in my life without having to call the father of my child each and every single month and ask him this and that in terms of the needs of the child. So like I said, that was my particular situation, and I feel like my journey was a bit easier and it was smoother because there were no disputes. But I'm still grateful that I still underwent this journey, because there are a lot of things that I overlooked and I did not consider, which were brought to my attention when I eventually did go to court. And I'm so glad I went through this process. So even though we are in good terms, even up to today, the child's needs always come first. That formal document was all that it was, a formal document, and should I need it, at least it's there. At least it's there. I do not have to go back and forth. So the court is very much fair in that it considers both the needs of the mother and the father without compromising the needs of the child. So don't just make up amounts, don't just make up situations. Go there with an open mind, go there and be and disclose, and yeah. That's where I'll pack it for today with this particular video, and I hope you have found it helpful. And tomorrow on my part 2, I will go into more details. But until part 2, please remember to like, subscribe, share, spread the word, leave a comment on the comment section below. And yes, until then,